Introducing the Institution of Surveyors of Kenya live stream and live chat. Do you have a question from any of the following areas? Land survey, valuation, building survey, land administration, engineering survey, estate agency, property management, and geospatial information management. Join the Institution of Surveyors of Kenya live stream and live chat every Friday from 2 p.m. to 4 p.m.
Good afternoon, ladies and gentlemen. For introduction purposes, I'm Liliana Mary Machio. I'm an advocate of the High Court of Kenya. I've been practicing as such for the past 19 years, and I major in family law, commercial, conveyancing, and other areas of legal practice. So this afternoon, I'm here to answer any queries you might have regarding women, land rights, succession, and inheritance. Now, we are going to start first of all about women's rights in respect of land. First, we need to know what is land. Of course, we all know there are different types of land. There is private land, that is you own as an individual. There is public land, which is owned by the public, anyone as a citizen. And also there is community land, which is owned by a specific community. Especially you find in Maasai communities, they own such kind of community land. I'm going to give you an overview of our women's position when it comes to land matters in the current constitutional dispensation. As you find, before the constitution came into force, women had issues regarding to ownership of land, because as men being the head of the house, they made decisions concerning ownership of land. When the new constitution came into force, that is in 2010, it has protected the rights of women. In particular, Article 27 of the Constitution, you'll find that women's rights to land are equal to those of men. Also, Article 45 of the Constitution, when it came into force, it has really helped the women in terms of women in marriage. Parties to a marriage are entitled to equal rights at the time of marriage, during marriage, and upon dissolution of the marriage. And after the Constitution came into force, there were certain policies which were enacted that have helped women a lot, and I'll mention some of them and the particular sections which have helped women in terms of inheritance, in terms of ownership of matrimonial property, and also how they've improved the issue of gender. The first act that came into force was the National Land Policy 2009. With this act, we've seen it has facilitated issues regarding improving of gender on land, and also the need of the women to inherit land. It has also protected the rights of that is widows and divorcees. With this National Land Policy, it also proposed an establishment of a matrimonial property framework that was able to provide equal rights, that is to men and women during marriage and upon dissolution of marriage. From there, we saw that several acts came into force. One of them was the Land Act 2012, the Land Registration Act 2012, the National Land Commission 2012, and the Marriage Act 2014. There's also the Matrimonial Property Act 2013. Now, with these acts in force, I'll be able to show you and demonstrate how they've protected the rights of the women. Now, first of all, I'll start with the Land Act that was enacted in 2012. Now, with this type of act, it has managed to define clearly what is a public land, what is a private land, and what is community land. With this act also, it has been able to define what a matrimonial home is, which has confirmed that it's any home which is owned or leased by one or both spouses and occupied by both spouses as their family home. Now, with this act also, there was something that used to happen. Men used to take, that is your husband or somebody's husband, they used to apply for loans. And they could take loans without the knowledge of the wife. With this act, it has come into force. No loan can be approved without the consent of a spouse, which is a plus because it never happened before. Now, when we move down to the next act, which is the Land Registration Act 2012, this one also created a strong protection of land rights of spouses. There was the issue of presumption of joint tenancy in respect of property which is either jointly registered or registered in one of the spouses' names. Also in this act, you find a spouse cannot dispose of a property, that is any land or any dwelling, that is maybe your matrimonial home, without the consent of the other spouse. So we call it a plus also this in protection of the women's rights. We've also, there's this National Land Commission Act which also came into place in 2012. In this act also, there has been gender equity in appointment in terms of the two-thirds gender rule in line with the Constitution, which is also a plus to the women. Now, we move down to the Matrimonial Property Act, which came into force in 2013. In this act, you find that married women have the same property rights as married men. In this act, you'll also find they've defined what matrimonial property means. It means any property that you've acquired during the subsistence of marriage. A couple have acquired during the subsistence of marriage. This property, it has given women a chance also to show their contribution, where the court can recognize their contribution in any form. That can be financial earned, non-financial contribution. Financial contribution, for example, if it's the land, if you've contributed directly by paying towards the purchase price. Non-financial contribution, which the court recognizes nowadays in terms of distribution of matrimonial property, it comes to in terms of provision of household costs and also participation in the family business or doing farm work, companionship, and all that are considered as indirect contribution, which is also a plus in terms of protection of women's rights. As we also go to the law of succession, that is about inheritance. That is about women also. Where do they stand when it comes to the death of their husbands? Now, as you are aware, or if I can clarify, the law of succession came into force in 1981. Now, there are two types of succession. There is one called the Intestate Succession, where a person dies and leaves behind a written will. There's also intestate succession, where a person dies without leaving behind a will. Now, there's also a type of will called an oral will, where somebody declares his wishes verbally, and this will is only recognized within 3 months of declaration of somebody's wishes, and it has to be witnessed by 2 witnesses. And if there is a conflict about the wishes of the deceased, by these 2 witnesses, then there has to be an independent witness. If this witness does not die within 3 months of declaration of his wishes orally, then it cannot be termed as a valid will. The only people who are given this exception where the court can overlook the 3 months period are army officers. This is an exception to this requirement. Now, that is as regards to the types of will or the types of succession. Now, when you reduce your wishes by way of a will, that is by way of a written will, it is the best thing because you are able, you as an individual, to state what you want or what you would wish your family to do upon death. It avoids those fights that you see emanating after the death of a person who has not left behind a will. Now, once a will has been made, there are various forms where you can store this will. There are various forms. You can store with your lawyer, number 1. You can store with the bank. Number 3, you can also store it with the court. But make sure at the time of making that will, at least somebody else knows of the existence of this will. Now, when we prepare a written will, it's required to be witnessed by 2 witnesses who do not necessarily need to be there when the testator is executing. That is, the person who is making the will is executing that will. Now, another requirement is if the person witnessing the will is a beneficiary in that will, then it requires 2 more witnesses to make the witnesses to be 4 in number. Now, I'll move on also to advise on the requirements for filing a succession case. Now, if a deceased person or the person who has died left a will, then all that is a person required is to have that will registered in court, file a succession cause and have that will registered against with that case. Once you've registered it in court, that case will be gazetted in the Kenya Gazette, where a 30-day period will be given to the public, to members of the public who have any objection to the contents of that will or to the case being filed. Likewise, when a deceased person dies without leaving a will, which is called intestate succession, what one is required in this kind of succession to file a succession case is to obtain a letter from your area chief who will confirm the beneficiaries of the deceased. Once you get the letter from the area chief, you are also required to get copies of the properties of the deceased, which include titles, shares in the bank, shares with various companies. You can have also shares in a company, and also vehicles, insurance, and all that as properties of the deceased. You need copies of those documents. You also require the death certificate in its original state. The court requires an original death certificate. You'll also require copies of identity cards of all the beneficiaries concerned. And if the beneficiaries involved are minors, this we are talking if the deceased was a male or a husband, then the widow has to provide copy of her ID and copies also of the IDs of the beneficiaries, and also a marriage certificate if they were married in church, or an affidavit if they were married traditionally. You'll also require sureties. Sureties are people who stand in based on the value of the property of the deceased. They act as guarantors. That happens when you want to appoint people who are called immediately after you file the case. The first step is for the court to appoint an administrator. The purpose of an administrator is to take care, to protect and preserve the estate of the deceased. Priority is usually given either to the widow or to the widower. And then it comes to the children to be appointed as administrator. Administrator can be one or two, but it's mandatory for administrators to be two if there are minors involved, if some of the beneficiaries are minors. So administrators have to be two. Now, once you filed all these documents in court, together with the petition for letters of administration, this succession course is usually gazetted, also in the Kenya Gazette. Once it's gazetted, if you are an interested party, maybe a beneficiary, you are a widow or you are a son, you are a daughter or a beneficiary of the estate in any manner, you have to keep on checking the Kenya Gazette, which is usually published every Friday. Every Friday you check. If you find it has been posted, then you as a beneficiary, if you are agreeable to the contents of what has been filed in court, then you don't need to file an objection. But if you are not agreeable, then you are allowed by the court to file your objection or an affidavit of protest. Because it's at that time an administrator is appointed by the court. If there is no objection after 30 days have lapsed, then an administrator is appointed by the court to protect and preserve the estate. And remember, as an administrator of the estate of the deceased, you can't sell the deceased property at that stage. Your work is to go and check the balances in the account. If the deceased had other properties, you go and investigate and come back and report to the court. If there's any damage being done to the properties of the deceased, you have the responsibility of ensuring that that property is protected and preserved. You get many beneficiaries once they obtained this document. The first document that is given is usually called a temporary grant, letters of administration. They think they can sell maybe the deceased property, or they can lease out, or they can do whatever they have to do. That is not right. The administrator's work is just to protect and preserve the estate and nothing else. So once this is done, once the letters of administration is issued, the beneficiaries usually have 6 months within which to file any objections. If there are no objections, after 6 months, the court confirms the grant, and you are given a certificate for confirmation of grant. With this certificate of confirmation of grant, the administrator has the responsibility of now transferring the properties from the deceased to them, and then from the administrator to the beneficiaries concerned. If the deceased left behind a will, then the properties will be divided as per his wishes. If the deceased did not leave behind a will, the law says all the children of the deceased are equal, whether married or not. That is, if the person died before the enactment of the Succession Act, which came into force in 1981. This includes children who are married. That is, even unmarried daughters are entitled in equal shares. The widow, once the grant is confirmed, she is entitled to what is called a life interest over all the properties of the deceased. Her life interest ceases to be in effect when she is remarried. Now, in case she passes on, the property goes to her beneficiaries in equal shares. Now, I'm also going to take you through. So that is about succession and inheritance. Now I'm also going to take you through the challenges that affect the women in getting justice. First of all, we've seen the first major issue is about our culture. It's our culture that men are usually the head of the house. We as women, we have to follow what they say as the head of the house. Now you can find at times in the process of that, the man as the head of the house, women's rights are affected. She can't raise her voice because as you must respect what the culture says when it comes to property, ownership or rights. So that has been a major barrier in it. Luckily enough, when the Constitution of Kenya came, the new Constitution was promulgated in 2010. Cultural norms that are repugnant to, that is to the rights of the women, those cultures cannot override a woman's right under the Constitution. We've also seen one of the major challenges is also the traditional gender biasness, which has always been there. Now, you find also when women are faced with the property issues or issues relating to land, there's that stigma and fear of negative consequences from the society. They fear if they start or if they complain, how will the society feel about them? So there's that fear and stigmatization, which we've witnessed it severally in many communities here in Kenya. Now, we've also seen another challenge in women getting justice is about poverty. You find a woman has a very good case, but in terms of finances, it prevents this woman from seeking justice. So that has been a major challenge in women accessing justice. There's also the issue of legal representation in terms of fees. You find when they approach a lawyer, they cannot even afford fees. So that creates also a challenge. You get a client or the woman has a good case but has no fees to pay to get proper legal representation. There's also the issue of literacy and also education, where most women are not informed of their rights. They don't know because of maybe language barriers. So I'll take you through what currently is happening and what has been done to assist these women in terms of discrimination. Lastly, there are two other issues, that is gender biasness by judicial officers. You find maybe you approach, you have a very good case. You approach maybe a male judicial officer who has taken stand, who still has that mentality about cultural tendency in terms of women and in terms of properties, in terms of inheritance. So you find they discriminate you due to the fact that you are a woman, and that has been a major barrier. Now, the efforts which are being made actually to remedy this situation, there are several. One of them, the courts. The courts, I'm happy nowadays, even the advisors as advocates, before you take a case to court, first try and resolve it outside court. You see whether you can articulate the issues with the other side, whether you can reach a mutual agreement before resorting to court. Another method the court has also introduced are alternative dispute resolution methods, where communities are encouraged to settle issues outside court. And also the other issues where the court The courts have also introduced, that is the mediation process, where parties are encouraged to mediate between themselves. The court looks at cases, they've done several cases and concluded several cases because of mediation. Because when you refer your matter for mediation, people are asked to remove their particular stance, and the mediator encourages them to settle. And whatever happens there remains there. So with this mediation process, where the atmosphere is not combusted like court, it's a smooth atmosphere before the mediators. So you find cases are being settled very quickly in terms of mediation. So we are also encouraging legal awareness programs where trainings are being done. This especially I'm encouraging. I was very impressed the other day. I appeared before a chief. The chief is well versed in terms of women's rights, in terms of succession, in terms of all that. So these are the same people that can be used on the ground for those women, for those upcountry women, for those who are not enlightened in terms of issues relating to property and also gender and also succession. So we can use people like the chiefs in the area so that trainings are done, and also develop training manuals which are in the native languages, because apparently you find the language used in court is either English or Kiswahili. You find a witness who is not conversant either in English or Kiswahili but understands the native language. So if the rights of the women in terms of property and the effects can be translated in the native language and be taken to the village level, to the ground where it started, then this issue can be easily be resolved. Now, we also have organizations that have come in terms of legal aid assistance. I would want even to recommend FIDA, where I'm also a member, because it has come up with issues or even mechanism where women can be able, they are trained how they can be able to represent themselves in court, especially when they don't have the finances. So they are trained to represent themselves in court, and they are sponsored even in terms of filing of cases and even being assisted on how to deal with cases. And I've even encountered some of them in court. They are very good in arguing their cases out in court. Now, there are also other organizations like CRU, which assist women in terms of finances, and also in terms of legal aid, in terms of trainings, informing them about their rights. We also have capacity development through judicial officers, legal officers, where they're even taught how they should not discriminate, what is the law. They should forget about the being discriminatory, but concentrate on what the law says and protection of the laws, the way the act says. Now, those are efforts, at least, which are being made to remedy the situation in terms of women's rights and property. I think I've taken you through, so maybe I can welcome you. If you have any queries to ask, then you can ask, then I'll be able to answer. Now, there's a question I've been asked: what happens when the woman loses the properties to male relatives of the husband? Now, usually this widow can first, for her to be able to recover this property, she has first of all to go to the chief, the way I explained to you. The chief will do a letter to her to confirm she's the widow of the deceased, and she also, the chief can also confirm who are the beneficiaries of the estate of the deceased, the widow included. Once she obtains this letter, she can arm herself and go to court and file a petition. While in court, she can be appointed as an administrator. Once she's appointed as an administrator, she can be able now to fight the male relatives through court, so that they are injuncted, and they are injuncted concerning the properties they had taken away from the widow. Now, there's a question I was asked, can parents inherit property of a deceased child? Yes, they can, if there is no beneficiary. If this child died without marrying or without having any child, then the property automatically will go to the next person who are the parents. Now, there's a question, when a man is married to two women, are they entitled to share the property equally? Now, I've talked about the Matrimonial Property Act, which came into force in 2013, which also provided ownership of property in polygamous marriages. Now, this property, it depends when it was acquired. If it was acquired when the first wife was there, then distribution can only be done between the first wife and the husband. Now, if other properties were bought after the second wife, then the distribution has to be done between the first wife, second wife, and third wife. And second wife. So that is how distribution is done. Because the second wife cannot claim a property that was bought during the marriage of the first wife to her husband. So that she cannot claim because she wasn't there when that property was acquired. Now, apart from land, what else can I inherit? That is what somebody is asking. There are shares. I talked about shares with several companies, Coca-Cola, banks. So those are also you can inherit. You can also inherit money from the accounts, that is shares. You can also inherit their life policies, insurance of the parents or whoever has passed on. Now, I was also asked about children born out of wedlock, whether they're entitled to inheritance. I can confidently tell, with the enactment of the Constitution, Article 53, all children are equal, whether born within wedlock or outside the wedlock. So when a deceased passed away and he had children born out of the wedlock, all those children are also considered as the children of the deceased, and they will be entitled to inherit equally as other children who are born within the wedlock. Now, I'm being asked another question. What is a woman's place in succession in Kenya? Now, succession, all married women, regardless, all illegal, let's say legal and illegal marriages are recognized at the time of the deceased death. So, for example, if the deceased married a woman through church or through the Attorney General, conducted a civil marriage through the Attorney General, which marriage is monogamous, then after a while he marries another woman traditionally, which marriage is illegal. Now, this woman will not be recognized legally if the deceased is alive. But when this person passes away, when the husband passes away, for purposes of succession, all legal and illegal marriages are illegal marriages. The women there are recognized as widows of the deceased. Same applies to the children. All children born within the wedlock and outside the wedlock are recognized as widows or children of the deceased. So that confirms that they are entitled Under the Succession Act, they are entitled to inherit the property. They cannot be left out. Now, I was asked about whether customary law affects the right of a woman to inherit. Customary law is only applicable in terms of inheritance if that person died before the enactment of the law of succession, which guides us on inheritance. That is in 1981. If that person died before 1981, then customary law will apply. Whatever your custom was in that community, that is what will be followed in terms of inheritance. But if the person who died, that is the deceased, died after the enactment of the Succession Act, then, as I told you earlier, all women, that is all women, whether married or unmarried, are entitled to inherit equally. That is all the children of the deceased, whether including women, whether married or not, are entitled to inherit the property of the deceased in equal shares. And I was asked, the law of succession does not adequately provide for widows in polygamous marriage. It does, because all women are recognized. So long as there was a valid marriage, all those women are recognized equally. All those widows will be recognized, and all of them will have something called a life interest. They have a right to enjoy that deceased property. And the only challenge is that they cannot sell that property without the consent of the court. They can only enjoy the property until they die. Once they die, if they want to sell the property, they have to seek the permission of the court before the same is sold. Now, there's another question I'm being asked, that what can one do if relatives are denying the widow, or if relatives are denying, I think, maybe a woman, a chance to inherit her father's property. I mean, relatives cannot do that because the law says they are entitled. So the only option left for this lady to do is to move court and seek appropriate orders, because her rights are protected under the law of succession. She has a right to inherit. Unless there is a will saying that she should not inherit, then that is something else. We also go back to the issue of the will. I'm being asked, under what circumstances can a will can lead to disqualification of a will. Now, I told you that a will needs to be witnessed by 2 witnesses. If it's witnessed by one person, it can be disqualified. I also told you that if the person who witnessed the will is also a beneficiary of the estate of that deceased person, then the will need to be witnessed by 2 other witnesses. So if you find that it's only that person who has witnessed and another witness, 2 witnesses, and it has not been witnessed by 2 other witnesses, then this will can be disqualified. Then another issue is, you find if the deceased person made a will during his lifetime, maybe 3 children had been born from the first marriage. I'm just giving an example. 3 children had been born from the first marriage at the time when the will was made. Then this deceased passes on, and the time of him dying, 2 more children had been born after the will. And maybe even after he died also, he had married another wife who has children. So this will can also, that can be a reason for disqualification of that will. Then another reason can be if you are able to demonstrate to the court that the deceased was not in his proper mind at the time of making the will, then that will can be disqualified. There's something I omitted to tell you. Who can make a will? It has to be a person who is 18 years and above, and who is in a proper state of mind. So if a person is ailing and is in a hospital, before that person reduces his wishes through a will, you must establish that he was in a proper state of mind before that will was made. Otherwise, the will be disqualified by the court. But parties are encouraged to make a will because those are your wishes. That is what you want. It avoids people to make decisions for you after you've died. So that is and also it avoids fights that you see every day in different parts of the country over a person who has not left behind a will. You leave people when they are settled, when everything is settled. So that is the advantage of making a will, rather than dying without leaving a will. There's a question I'm being asked: can a woman possess a property of the late husband without marriage certificate? Now, as I indicated earlier, before the Marriage Act, that is 2014, there are marriages, different types of marriages that are recognized here in Kenya. There is a customary marriage, there is the civil marriage, there is the Christian, there are those Christian marriages. Then there is marriage by cohabitation. That is before the new Marriage Act 2014 came into force. So for this woman to possess a property of the late husband without a marriage certificate, we know before 2014, only marriages, that is civil marriages and Christian marriages, are the ones that provided marriage certificate. Customary marriages, parties were allowed to do an affidavit of marriage, but that is not proof of marriage. For that, for you to prove customary marriage, you need witnesses to prove whether the marriage was conducted according to your customs and traditions. Marriage by cohabitation, in order to prove that, you also need to prove to court long cohabitation through witnesses and even through documentation. So with this woman, it depends on where she falls, where the husband passed away, under what category she falls. If she able to, so long as she's able to prove she's a wife, then the court, she can have the right to inherit her late husband's property. You do not need a marriage certificate. But under the new act, the Marriage Act 2014, it says any marriages, even the ones that were conducted before, you are meant to go and acquire a marriage certificate, including traditional marriages that did not provide marriage certificates. Now, I've been asked again to take you through, first of all, a will, the importance of making a will, the process of starting a will. As I said, a will is a statement. You make a statement of your wishes, of how you wish your properties to be distributed upon death. You can also state how you wish your funeral to be done, how you wish it to be done in terms of your clothing if you die, your properties including clothing and all. You reduce anything you want in writing. through a will. Now, and I told you there are two types of will. There's that written will and oral will. And if there's a conflict between oral will and written will takes over the oral will. Now, the process of starting a will is just you can visit any law firm armed with all your assets and also armed with your instructions, how you want your estate to be dealt with. Now, in the will, I forgot to tell you, there's you appoint somebody responsible to act as an executor of the will, somebody who will carry out your wishes. That person is usually called an executor. You can appoint one, you can appoint two, you can appoint many executors as you want. It can be an individual, it can be even a bank, it can be even a company. You can appoint to carry out your wishes. So that is also one thing that is mandatory. You need to know who will carry out your wishes. You have to mention it in the will. Now, somebody is asking me, kindly tell us why lovers need to get a premarital counseling. Now, this is important. In my practice as a family lawyer for the past 19 years, I've seen couples. It's very important before you get married, marriage is a commitment. It's a life commitment. Before you enter into that commitment, first you need to set your goals. Both of you sit down, discuss what your wishes, what your goals are, what your plans are in terms when you get married, in terms of children, in terms of sharing of responsibility in the house. These are the things you need to know from your partner, whether they have the same goals as you, whether they have the same expectations. Those are the things I've seen which are causing marriages to break down prematurely. So it's usually very good to understand each other's expectations. Do they tally? Are they things you can deal with once you commit yourself in marriage? Because it's not easy. Once you commit yourself, you can't complain if you had discussed those expectations. The reason why they break down is because you had not sat down and agreed what your expectations are, what your plans are. So once you enter the marriage without discussing these things, you find when they start coming in, you feel frustrated, you feel somebody is letting you down, and it's not that person's mistake. It's because you didn't discuss your expectations before committing. So before committing, think through all these things. Think about the properties. If you acquire properties, how are you going to share the properties? That is why even the Matrimonial Property Act has given parties a chance of discussing or doing, they are called prenuptial agreements, where you can agree of properties that you are going to acquire. How are you going to deal with them so that it's clear? So when you're going to this marriage, you are tuned in, you know exactly what you want, and you know what your expectations are. Now, somebody is asking whether the rights, the rights, that is the rights I talked about in the land laws, the Land Act, whether the rights are protected. They are there. For example, when you want to take a loan as a man, it's either way. If it's either party, that is either spouse, has to obtain the consent of the other spouse before you can take a loan against the title, or before you can sell, that is matrimonial property and matrimonial home. And also matrimonial home has also been where you stay. where you are bringing up your children or where you're bringing up your family has been protected, it cannot be touched without the consent of the other spouse. So these land acts have protected women in terms of their rights. Now, I think I'm done with most of the questions that were asked. If at all there are any queries, any questions, or you might want to comment and which have not been adequately answered, maybe you can share your comments through WhatsApp. That is WhatsApp number is 0724 929 737, or you can also email, that is info@isk.or.ke. I want to finalize by saying that you keep on sharing your questions, your doubts. They'll be adequately answered, and I hope you've managed to learn one or two things from this conversation, and will be available to give you any answers to any questions that you may want to be answered. Thank you.